Mami Mate.
Honorable Alhaji Inusah Fuseni, former MP for Tamale Central. Now you know entry komo. Honorable Mwaji.
Me just want to concern.
Boko na uswe.
Me hoya.
No, say who is kasa? Say who is kasa?
Skade.
Daily Dispatch say how some Mahama appointees allegedly spent over 8 million on properties in Dubai. And now we do picture abeto back page. Now we see details now emerging. Details are emerging about how members of the SY John Dramani Mahama's government acquired properties worth 8.409 million Ghana cedis in Dubai. Now, what's a report? You know, Wabo Niwa say former minister MP for Tamale Central, who served as minister for roads 2013 to 2017, owns 20 apartments across 5 luxury buildings with a total of estimated value of $7.240 million. Na Obobako Jumeirah no triangle village no wo bi ho o de minimum pa ba bia ya twe epono ye de dana kosi pono so afa Millennium Place wo bi ho afa wo bi wo 2 apartments e wo Windham eno ye Marina no ye ba bia ya twe sea no e de aban Marina Resort ho no mi kodim birthday kra wo ho kama pa and I go saw be Sky Central Hotel and the one hotel ni nyina wo dia asemi eti say
oh but what story no and first of all story no any accurate
okay
because in the first place let me a minister from 2014 to 2016 or January 2017 so that's the first thing. But the second thing is that Ono Ankasa say allegedly, alleged. So because of that, me who story then me refer here some of my lawyers.
Thank you.
Or me say Mami Nkasa be brave. But he says details are still emerging. Until you better details in so. But this could be one of the attempts to deflate the attention that is being drawn on government onto former ministers. And so we have to wait for the details. And my lawyers are stating the story clearly.
As Ben Ephson will take the trouble to call you for verification and now
no, one call me.
Now, I'm passing a property back could be crowd.
No, let's wait. You see, this matter haven't been published at this time. Say me, Inusah Fuseni, me were 20 properties in high end. Let's say what about Jamaica and Pomidi and Nimhombo? Say I mean in Dubai, it's not only very telling and revealing. It's also a story that goes to the reputation of the individual. And the man change. Let the details emerge. Let my lawyer study so that I don't compromise my rights to take further action on this matter.
Oh, okay. Because who are the Sianan can force Animan Yemfantagi will be blue.
So that is why I don't want to speak too much.
Okay. Now, you are to forcing one near Richie Jakpa. A case, no. Pacho, when did you actually kakra?
Oh, to force on any Japan case, no. Indeed, Attorney General or the state against force on any Japan case, no. We actually
na Adana, Akoye say NDC MPP.
I best have because of the emergence of the tape. Yeah, before that, all that we were saying were suspicions. Yes, sir.
Sure.
Say the current regime was going against the previous appointees of the previous regime. So there were suspicions that we entertained. Now, Cecilia, Tiffany P, it has somehow validated those suspicions. I mean, if it is indeed true, say, Attorney General Akachre Japase, na case numpo, not only on Pese on Pushi, na Kenofurata, any Omanpenin, na Nakufado, Omono, pressurizing to prosecute, then it lends credence to the fact that this is political persecution.
Oh, okay. Now, Mami Musa,
case now had drifted towards partisan politics.
Mami Musa, what DB? It emerged, the Attorney General release even WhatsApp messages at Dakpa send a man no be 62 messages and now we muka krebi at the buyer and no what does it tell or what story does it tell? So
the court has admitted text messages into evidence under section 51 of the evidence decree. It should say the text messages are relevant to establish the credibility of the persons who made those allegations. For instance, Japa and Attorney General. They are also relevant to the point that Nka Enihwa, the fact that Omoashia, Omoa Kasama, Omo would not have been there. So they go to establish a fact, say, Omoswashia, or they were talking to each other.
Per the ethics, any rules are moody diasem our court no prosecution is she bad say oni ebia the accused ebenya conference bi ana bibi etisa.
Oh, mean to mean say prosecution is bad, but rules, there were rules and ethics regulating how a prosecutor interacts with an accused person. There were rules. Because you see, young constitution makes it a fundamental right of the accused person to be presumed innocent. Young constitution as a guarantee the right to fair trial. Edema accused. Yeah, and rules of ethics is to say who are prosecutor. You can only meet the attorney general. You can only meet the accused person in the presence of a lawyer. Why is that so? Because Constitution will say, I mean, even if you are going to take a statement from the accused person, it must be before in the presence of the attorney or an independent witness. Identity. There's supposed to be a rule against self-incrimination. Say, when to me, Michelle would a prosecutor, Nami Kasa, Nekasano, Etimia, just like you asked me in the interview, and I talk in the way that I incriminate myself. That is not allowed under the law when the prosecutor is dealing with an accused person. And so the Attorney General's conduct was not only scandalous because Attorney General or a leader of the bar on him say won't mean share accused person without the presence of a lawyer. On him say you can have an informal contact with the accused person through phone calls and text messages and WhatsApp messages. On him, sir, the Attorney General knows that it is unethical to maintain contact with an accused person, a person you are prosecuting. On him, sir. If an Attorney General falls in love with an accused person, that will be gross unprofessional conduct, gross misconduct. So you see, so this is a person, even though a man, that you have taken to him and you are prosecuting him. So it goes to the core of the prosecution. You have already sown doubt in the prosecution. You understand? Until
now, Mami Musa, obi a argument be say the prosecution no per se ka the third accused one man it be prosecuted and now ye de o secure conviction e wo ato force and so senka you would have made him a prosecution witness.
Exactly. Exactly. And that is again part of the ethics of the profession. Say, oh, there is every right for an accused person to be made a prosecution witness through plea bargain. Say, there are a number of people involved. A number of people who have all acted together to commit a crime, or alleged to have acted together to commit a crime. Now, in the scale of things, obedience, the participation, the Attorney General wants more evidence because to get the evidence is difficult. The law allows the Attorney General to, before Overcourt Court underlined, to take one of the accused persons and turn that person into a prosecution witness and make that decision known to the other accused persons and the court, so that the other accused persons can prepare to cross-examine the prosecution witness.
Okay.
That is the fair trial principle. You must make, when you take a decision to make through a plea bargain or any other arrangement to make an accused person a prosecution witness, you must disclose that so that it doesn't look like kangaroo court. While they are talking with the accused person, only Attorney General Kasa. And so, whatever the accused persons, the co-accused, tell the accused person or their colleague, he sends it to the Attorney General. And then it becomes a kangaroo trial. That is why the law and the rules of ethics are frowning upon that conduct.
I see. Now, Mami Musa Diewi, there be a lawyer for Musa, evidence is not counted. There be evidence by Kukura Betimi a trap. Will be so counter evidence be about 200 mu. Now, Mami Musa, sadie a war text messages ni tapes near the idea no. Would it have effect on what is before the court?
So the tape, WhatsApp messages, the telephone conversation, the meeting, all go to weight. What weight will, they are relevant in establishing whether or not the Attorney General had met, Semdi Kankasa, had met the accused person. They are relevant to the extent that it was there any talk about the accused person procuring evidence or leaving evidence against his co-accused. Now, if that evidence is not rebutted in court, what is there to substantiate that? It will be on the tape and the meetings and all those things. Now, but it is important to say that in a criminal trial, the prosecution's duty is to lead evidence to establish the guilt of the accused beyond reasonable doubt. Now, the duty, if you can call it that, of the accused person is to show doubt, reasonable doubt, in the evidence of the accused person.
Mm-hmm.
So that is the opposite. So you lead evidence beyond reasonable doubt to be able to secure a conviction. The accused, his duty is to show that, to point out the inconsistencies, is to show doubt in your evidence. And so let's wait and see how the court will evaluate that. But media, I can say that even now, as we speak, the accused persons have succeeded in showing doubt in the evidence of the accused, the prosecution, because they have led evidence of much less. All that is happening is because of a desire by the government to get the accused persons into jail, and particularly the first accused person. And that desire is motivated by the fact that accused person occupy a seat in parliament, and that seat, say, becoming vacant, it might lead to the success of the government in a by-election in its constituency, and tilt the numbers in parliament in favor of the ruling government. So they have already provided some reasonable explanation to show that there is doubt in the criminal conduct of the accused persons But what is pushing the Attorney General to prosecute? And yet justice. But the fact that there could be a collateral benefit in conviction. So they are
collateral benefit in conviction. As in what?
As in the by-election being held in the constituency and the by-election returning a candidate who will stand on the ticket of the government to parliament.
And only maybe was secure conviction before 6 months to elections. It will no better not me.
Oh, so the matters there PCC and have come out at a time that is less than 6 months to elections. Yes, sir.
Sanity.
So that is the unintended consequences of the prosecution.
Oh, okay. Now, my major idea with you, me say campaign no a woman ye party to the suit no offered say okay scan kra na woman wo betua woman ye nyina wo befa nyina eno no edi entina court no ampene because they were not party to the suit or what?
Nye court no ampene.
Prosecution never say ampene. So Abasa, now what is the interest?
Oh, that's a very good question. That's a very good question. Media over asked Attorney General, but that's a very, very good question because say willful coercion financial loss is just like taking somebody to court, a private person to court, on fraud by false pretenses. So, but that false pretenses have led to a loss to the state, not the individual. Individual, it will be defrauding the state. So now, so the matter in an individual private case, if two private persons are involved in such a case, what will have pushed the complainant to go to the police to say that, well, Munchi Akurawe because we defrauded me, we Jimisika, we Yami Kanana, Ajimisika, and so I did the also the moment of family. And the one who push a complainant to the police station will be Nisika. Yes, sir.
Yeah. That is the interest of the complainant.
No, that's the interest of the complainant. Now, so what is the interest of the state in a willful coercion financial loss?
Asemo.
In yes, Canana.
Scanner.
So why will we say that we don't want the money?
In case Manubu to Sumnaso, sir, if the Attorney General or the prosecution is able to secure conviction, as said, he can want some here. Sikanabeshi.
Basically, any first accused person or any third accused person or second accused person no, almost fairly and only prosecute. So, second no, what you are second of a company no, and the company came and said, well, media. Because of my reputational damage that I will suffer if this case goes on.
Because baby for me to say Dr. Atufosin cry say okay well your arrangement to be said nka obetua scano
on one kata
be sabai
no I don't think that that would have been no I don't think that would be appropriate because say the government is following the money. And yes, sir.
Sanity.
So, and the money is where?
A money no, a work company no.
But the government at the force and any Jaguar court because government thinks that more play pattern cannot complain.